Okay, we're pleased to welcome Professor Anna Marhold. She is an assistant professor in energy markets regulation and a senior researcher at the Tilburg Law and Economics Center at the Tilburg Law School in the Netherlands, where she researches and teaches in the field of international and European law. Her specializations are international and European energy law and regulation, international economic law, and international trade law. Her PhD thesis explored the challenges of changing energy markets in international trade law. In 2015, she was a Marie Curie Early Stage Research Fellow in the framework of dispute settlement in trade, training in law and economics at the Graduate Institute in Geneva, Switzerland. She was an EU-US Fulbright Schumann grantee and visiting scholar at NYU Law School. And she is a graduate from the University of Amsterdam, where she holds a BA in Slavic Languages and Culture, an LLB in Laws, an MA in Russian Language and Culture, and an LLM in International and European Law. From there, she went to the European University Institute in Florence, Italy, where she holds an LLM in Comparative European and International Laws and a PhD in Law. She spent a lot of time in school. She is this summer a professor in our program, and so we're pleased to have the opportunity to have her here to present this hot topics called Solving Energy Disputes in the WTO. Is it the right forum? A critical assessment. So please join me in welcoming Professor Marhold.
So can you all hear me well? Is it amplified? Okay. No, not amplified? Okay, but can you still hear me? All right, so I'll just try and speak up. First of all, I really want to thank Vermont Law School for inviting me to teach here this summer. It's been a really great experience. I want to thank Kevin and Courtney and also Melissa and everyone for making me feel so welcome, because it's quite far away from where I am. Now, let me just start, because the obvious question I always get is, Tilburg? Where is Tilburg? Now, I have to tell you, 2 years ago, I would have asked the exact same question. But Tilburg University is a university near the border of Belgium in the southern part of the Netherlands. It's halfway between Amsterdam and Brussels. And we are one of the few centers in Europe that does quite specialized law and economics research. While law is quite doctrinal in Europe overall, we are quite interdisciplinary, and so we do have a lot of contact with US universities, and we do have a lot of scholars who come and lecture, especially in the field of law and economics, and for instance also in the field of energy. So if you're ever interested, please talk to me. I also want to say that my talk today is actually very different from our last talk, because our last talk, which I thought was great by Sarah Bronin, was really focusing on what's happening here on the local scale in the US. And I'm going to take it to the other extreme, namely I'm going to talk about international trade treaties that countries are party to. And I'm going to discuss with you today the fact that we see an increase in energy disputes in the World Trade Organization. And we see that this is a system that wasn't originally administrated to deal with energy disputes. So this kind of poses all kinds of problems, and moreover often has very paradoxical outcomes. So I'm saying that we should do something about that. But moreover, because I do think that there has never been a time in international trade law that has been more critical than now. I think international trade has never been more in the news since we see developments with the Trump administration and with Brexit. And also because I understood that Vermont Law School is focused heavily on US national law, I want to talk a bit about the international trade system and the laws that are in place and what those mean for our global society. So I know I'm preaching, so first of all, I'm going to introduce the system of the WTO and the cornerstone provisions in the WTO, and I'm going to talk about energy disputes that are occurring more frequently in the WTO over the past 10 years or so. So I know I'm preaching to the choir here, but I couldn't resist, and I just had to include a Trump tweet on trade. Because we do see that we live in a time where globalization is being heavily criticized, and we do see the adverse effects of globalization, and we see a lot of protectionism rising, not only here, but also with regard, for instance, to Brexit, etc. So I had to put here this tweet saying China has been taking out massive amounts of money and wealth from the US in totally one-sided trade, but won't help with North Korea. Nice. Okay, so actually there's many contradictions in and of itself in this tweet, which is no surprise to you all. But I want to say basically that what is very interesting here is that Trump says that it's very one-sided trade with China. Well, in effect, China joined the World Trade Organization, what we're going to talk about, only in 2001, and had to join the World Trade Organization under more stringent requirements than other countries did that joined prior to China, for instance, in 1995, which was the establishment of the World Trade Organization. So that's already a contradiction. In fact, China has more stringent requirements in international trade than a lot of other countries, including the US. So this is kind of interesting to note. Okay, so let's talk about the World Trade Organization. What is it and what does it do? The World Trade Organization is an international organization based in Geneva. There are 164 members to the World Trade Organization at present. It has evolved from the General Agreement on Tariffs and Trade, which was instituted after the trade wars in 1947, and established basic rules of trade between goods between nations. Now, in 1995, the World Trade Organization was established, and it added all kinds of other agreements to the Agreement on Trading Goods, and it expanded its membership vastly. So what does it do? It hosts, it's in charge of administering agreements on trade in services, trade in goods between nations, and also trade in intellectual property rights. Moreover, it provides a negotiation platform for 164 members at present. So everything in the WTO is based on negotiations. And everything can be renegotiated in principle, although in practice we see that this is very hard, because I'm sure some of you have heard about the Doha round of negotiations that has been stuck since 2001. One of the reasons is that we are going to a new level of trade integration, so it's not only anymore about tariffs, but we're venturing into other issues such as non-tariff barriers. You also see that because of this gridlock on the multilateral level with the World Trade Organization, you do see a shift to negotiating other free trade agreements, which are also highly controversial at the moment, such as the TPP, the TTIP, well, NAFTA, there's the talk about NAFTA being renegotiated. These are all free trade agreements where countries try and go beyond whatever was agreed on in the WTO if they can't do so on the multilateral level. One of the success stories of the WTO, though, is its dispute settlement mechanism. This is a state-to-state dispute mechanism where states, if they fear that their industries have been harmed, can start a dispute against other states based on the violation of these rules. So there's no central investigative authority that investigates whether trade rules have been violated, but it's really a state-to-state dispute settlement mechanism. So what is the whole idea behind international trade treaties? What are the gains from trade? The whole idea is that economies should be open and that countries should focus on their comparative advantage. So they should do and develop the industries that they're best at. And if every country does so in abstract, that should lead to a full development of their economies, and everybody will benefit because you specialize and you make the size of the pie bigger. That is the whole idea about the gains of trade. So what are the features of trade policy as such? So you will have international trade in goods without tariffs or other barriers. No quotas on imports or subsidies for local producers. You will have trade in services without taxes and other barriers. You will have an absence of other trade distorting policies, such as taxes, law, regulations, subsidies, and other measures that might give an unfair advantage to an industry. You should have unregulated access to markets and market information. And ideally, to make it all a holistic endeavor, you should also have policies dealing with antitrust or competition policies, or at least some rules to prevent the abuse of a dominant position. Now, this last element is not present in the WTO. It's very difficult to multilateralize competition policies, but it does have rules on all these other elements in international trade. So trade agreements try and combine these elements into what is called a free trade agreement. Basic rules of WTO law are based on non-discrimination, based on most favored nation treatment. I don't know if you've ever heard about most favored nation treatment, but it basically means that if you are a WTO member and you accord a certain favorable treatment to one country, you have to accord that favorable treatment to all other members. Moreover, there's also the national treatment obligation, which means that you cannot, as a WTO member, treat foreign products and services suppliers less favorably than like domestic products. What are like products? Two simple chairs. They look the same, right? So what if one chair is made from sustainable wood and the other chair is not made from sustainable wood? Are they like products? This is a very controversial question in the WTO and not something that you can solve easily. If you want to discriminate on the basis of this, you will have to justify it in the exceptions available to you under the rules. But you could see that this is definitely some controversial topic that occurs in the WTO with regard to trade regulation. Usually, we look at a product and we look at the physical characteristics of the product, the end use, and the tariff classifications, because all products in the world that are globally traded are also classified in a classification convention. But consumer tastes and preferences can also be taken into account. So if you treat a product differently because of the way it's being produced, that can also be taken into account. Then there are also important rules on market access. Countries can discriminate against one another through customs duties, but they are discouraged. So they are not prohibited, but they are discouraged. So if President Trump says that he will raise an import duty on cars from Germany, for instance, he cannot legally do so above the duty that has been agreed upon in the tariff schedules that the US has signed up for. However, tariff reductions are transparent, so this is important. Then there is also a prohibition of quantitative restrictions. So countries cannot decide to stop imports of a certain good into their territory or subject them to a quota. Additionally, there are also non-tariff barriers, so there should be no discrimination on the basis of customs formality, government procurement, or technical barriers to trade. So this ensures that you have open markets and that you ensure market access to products. Just in terms of restrictiveness, free trade would be the most optimal scenario. Tariffs are allowed, but discouraged, but are still transparent because they are taken up in members' schedules that they agree upon in their negotiation rounds. Quotas are prohibited because they are intransparent, and the far worst thing for international trade is a trade ban altogether. Then there is also exceptions. So WTO members may discriminate, but they have to do so, and they have to make sure that it qualifies with the exceptions. For instance, for protection of the environment, public health, or public morals, national treasures, and also national security. So this gives members a leeway to regulate and make sure that their policies take into account the issues with regard to international trade law. So that's all great. Although it's not so great, because what you see now in the backlash is that the problem is that the gains from trade are not always well translated into national policies. So the way the gains from trade are distributed, because you do see a growth, an economic growth over the decades, it doesn't mean that countries institute policies to mitigate comparative advantage and the change in labor patterns that you get from globalization. And this is, I think, a lot where the discontent comes from. So I think people tend to confuse what national policies do or should do to redistribute the wealth with blaming international trade. And of course, international trade is always an easy target. That's not to say that the system is without problems. The system is definitely with problems, and you could say that there's a discrepancy between the gains for developing countries and developed countries, amongst others. But overall, this seems to be a very pressing problem at the time, that countries don't differentiate between what can be blamed on international trade and what can be blamed on internal policies in states. Again, so great. But how is it relevant for energy? Because so far we've been talking about the trade in goods, the trade in services, trade of intellectual property rights. How would that apply to energy? Well, interestingly enough, for a very, very long time, if you would ask people working in the WTO or knowing about WTO law, they would have said, it's not important at all. The WTO is not relevant for energy trade altogether. Why? Because for decades and decades, energy trade was confined to trade in fossil fuels mainly. And it was mainly done by vertically integrated global conglomerates that preferred to settle their things outside of the system. So this created a whole misconception, basically saying, oh, the rules of international trade are not relevant for energy trade altogether. They don't apply. They're just for trade in manufactured goods and services. And the rules of the WTO don't deal with for instance, trade in petroleum or trade in renewable energies. Wrong, because first of all, if you look back into the first tariff schedules that were already instituted in the 40s, you see that petroleum products were already taken up in the schedules. It's more that the way energy is traded is different, or was different for a long time. That didn't make it de facto relevant, but legally, energy products have always been on paper applying or relevant for the rules of international trade. The first realization that this was relevant was the 1970s oil crises. So this was the first time energy issues would be discussed in the GATT, which was back then still the GATT Forum, the General Agreements of Tariffs and Trade. And countries were discussing what to do with practices, restrictive practices by energy exporting countries and how to tackle that. However, with little success, but it was a slow realization that the rules of international trade as a multilateral framework were also relevant for energy trade. Then for a long time, it was again very, very quiet. But then two major developments took place, I would say in the last 10 years or so. When I, before starting my PhD, which was on this topic, when I would talk to people saying, well, I'm writing on WTO and energy, you even have WTO officials telling me, well, but energy is not important in the WTO. Why would you write about that? It's not relevant at all. So two things changed. First of all, the types of energy we started trading cross borders started to change significantly. There's a lot of trade in solar panels. There's a lot of trade in components for windmills, etc. So we are not only trading fossil fuels any longer. We're trading renewables, and we're trading so greatly. And you, I'm sure, might know that, because I understand that you have also a national solar panel industry here, and that is maybe trying to lobby your government to institute anti-dumping duties against solar panels from China, which is all under the laws of the World Trade Organization. These are regulations on the World Trade Organization laws. So that's the first major development. The second major development is that since 1995, a huge amount of major energy exporting, producing, or transporting countries has joined the WTO, mainly also in connection with the fall of the wall, but also a lot of Gulf countries or OPEC countries have joined the WTO since 1995. Ecuador is an OPEC country. Russia, of course, joined in 2012. Ukraine, important for transport and transit of energy. Saudi Arabia joined the WTO in 2005. Oman joined. Kazakhstan joined very recently as well, which is a major gas exporter, and counting. So this is already on top of all the major energy producing countries that were in the WTO, of which by now the US is also one. Since 2008, the shale gas boom, for instance, your policies have also been changing because you had an export ban actually on exporting fossil fuels from here. So these are two developments that have really started to trigger disputes on energy in the WTO. And I think that this amount of disputes will only grow more and more. The problem is that the rules of the WTO, as I discussed with you, these basic rules, apply to trade in energy. However, they were not drafted at all with energy in mind initially. Why not? First of all, because as you saw, there are separate agreements on the trading goods and, for instance, on the trade in services. This is just a snapshot that I'll give you, but this is just a division. In the energy sector, traditionally, it's very difficult to sometimes distinguish exactly what elements are goods and what elements are services. You used to have, and you still have in many parts of the world, huge vertically integrated energy companies that do everything from producing energy to transporting it to transmitting it, etc. So there it will be very difficult to codify exactly what is a good and what is a service and what is covered by what agreement. One difficulty. A second difficulty is that natural resources, and I'm talking here about the more traditional fossil fuels, petroleum, coal, natural gas, etc., are unevenly distributed around the world. And the World Trade Organization was set up as with rules in mind that would help access to markets. So this was more drafted in mind with traditional producers that want access to an export market. But with fossil fuels, it's usually the other way around, because if you are in possession of a fossil fuel, you don't need access to other markets because people want access to you. But the rules of the WTO, they don't take that into account. They are really focused on import markets and not on access to supplies. So this is one big issue. This means that if you are in possession of natural resources, under WTO law, it's very difficult to force any supply to these resources that countries would want. Moreover, there are very paradoxical outcomes, especially if you look at renewable energy disputes and issues such as fossil fuel subsidies in the WTO. I'll give you an example. For instance, with regard to subsidies. So the WTO, apart from having rules on trading goods and services, also has special rules on regulating subsidies. So determining how countries can subsidize national industries. Rules on subsidies are only relevant for goods at this moment, not on services. But you are allowed to subsidize under WTO law. However, you shouldn't affect international cross-border trade negatively. And certain types of subsidies are completely prohibited under WTO law. If you look at a definition of a subsidy in WTO law, you usually look at a contribution by a government through which a benefit is conferred, and the benefit must be conferred to a specific recipient. Then you have three categories of subsidies. You have those that are completely prohibited. So all WTO members should refrain from subsidizing in this way. First of all, that's contingent on export. And second of all, when you have local content requirements. This means that if you have certain subsidy schemes in your national jurisdiction, they cannot have any local content requirements altogether. Then you have other subsidies that are actionable, which means that they are allowed, but they shouldn't affect trade negatively, and they shouldn't cause harm to another WTO member. So if a WTO member has a negative effect from your subsidy, it can challenge you in front of the WTO in a dispute settlement panel. There used to be a category of non-actionable subsidies for certain policy goals, because as we know, for instance with renewable energy, there are some very legitimized policy goals for subsidizing certain schemes, right? So how does that work out? We all have a lot of renewable energy support schemes, whether in Europe or the US or in Canada. And a lot of these schemes would clearly fit the subsidies definition, first of all. And secondly, a lot of these schemes have local content requirements, meaning that you can apply for the scheme if you're located within either a state territory or a country territory or sometimes within a regional territory. But what we have just seen is that that is illegal under WTO law. So you had a major dispute against Canada, which had a local content requirement on the manufacturing of wind turbines. And Japan and the EU protested against that and started a dispute against Canada. Now, the appellate body in that case already knew that it would be very tricky if it said that it was a subsidy. So it went into great lengths, what some people call legal acrobatics, to not define whatever Canada, this was the province of Ontario, was doing, to not define it as a subsidy. However, it had a local content requirement, and Canada was seen in breach of WTO law and lost the case. There are many more renewable energy disputes than fossil fuel subsidy disputes. Namely, there are no fossil fuel subsidy disputes. But renewable energy disputes in their nature and the way they're administered make them much more sensitive to dispute settlement in the WTO system. So you will see a lot of disputes against schemes for renewable energies, but what is worse is that you have no exceptions anymore under WTO law to legitimize such subsidies. This is a big problem. We saw that there used to be a category of subsidies that was allowed for policy goals, but that category lapsed because developed and developing countries couldn't agree on the prolongation of that category. This is just one issue with energy disputes in the WTO. You also see more traditional energy disputes occurring more frequently. For instance, at the moment, Russia has started a dispute against EU energy policy, the third energy package. So this is the whole liberalization energy policy of the EU, which would have been unthinkable a couple of years back. So you could see that it's really starting to grow as a forum for solving energy or solving energy disputes. So just to wrap it up, solving energy disputes in the WTO. One huge advantage of the WTO is that it is a multilateral forum, and you have a lot of big energy players already being members. So with a lot of specialized energy treaties, for instance, such as the International Energy Charter Treaty, a lot of major energy players will not be a party to that. But because the WTO isn't only about energy, in fact, it's about many other things, you will have a lot of players and big energy producing and exporting countries, but also countries trading in renewable energies are already there. So this provides some potential for negotiations on some rules. The disadvantages are the rules. The rules are not really fit to deal with energy disputes and can lead to absurd outcomes. And this is something that should be tackled. For instance, through adapting subsidies rules in the WTO. They need a revision. They at least need some exceptions so that countries can have certain schemes in place that actually serve a good outcome or a good policy goal. So you could think about maybe negotiating a WTO agreement, an internal agreement on energy amongst members. However, as we just discussed, the WTO is quite in a gridlock at present, so this is a problem. It might work in the future, and I would definitely be in favor of something more rules that are more adapted to the energy industry. But what is more realistic now is that you see development through case law, but although quite suboptimal development, for instance, saying that renewable energy schemes are not a subsidy by making a very complicated legal analysis why they would not be a subsidy when they clearly are a subsidy, and maybe that should be all right that they are a subsidy. So these are some options that I could map out, but I think it's more realistic now that we will see development through case law. If you're interested in this at all, there's a great NGO called the International Center for Trade and Sustainable Development, and they offer a lot of publications in this field that are freely available. They have a lot of good research on subsidies and energy and environment in international law and in international trade law specifically. So you can find a lot of good information there. But before that, I think we're dealing with bigger issues. And so I have to go back to La La Land. And we have to rethink, I think, more crucial elements of the international trading system, how countries can make it a more inclusive, more fair trading system, and how we can, I think, prevent economic protectionism and nationalism, because it really doesn't work on the long run, I think. So that was my presentation. Thank you.
We're going to open it up to questions now. So just raise your hand and we will bring the mic over.
Your presentation focused on energy production primarily, and I was interested in energy consumption. Particularly years ago, maybe a decade or more, I reviewed a number of cases in the Clean Air Act area in which various issues arose regarding WTO pertaining to car pollution and so forth. Have you looked at, I'm sure you have since you've done a doctorate in this area, have you looked at the area of energy consumption, that is cars and other kinds of things, and the extent to which the WTO has played a role in that area?
Well, thanks for your question. It's interesting because actually today we had a class on emissions, and we were, for instance, discussing border tax adjustments that take into account carbon emissions. So whether you could discriminate on a product, we were talking about these like products, whether you could, for instance, discriminate on the border, saying that a certain product has been produced with so much energy consumption and emissions, and to what extent you could discriminate on the basis of that. Now, certain countries have threatened to actually use such a border tax adjustment, but it is very controversial, and it's also feared to institute trade wars. But these are definitely things that could be taken into account potentially as a way to maybe also manage fossil fuel subsidies or the curbing or reduction of fossil fuel subsidies. So I would say the problem is with the WTO that it is about trade, and in the end trade affects everything, so it's very difficult to go into every area and try to improve the world everywhere, but this would definitely be something that could be and should be considered in the WTO, I think.
In the area of solar panels in the U.S., in the Obama administration, there were tariffs placed on Chinese panels due to concerns about dumping of those panels in the U.S. And now there's Solar World and others are raising concerns once again, and there's at least discussion, I guess, of further tariffs. What protections does the WTO provide, though, on the side of the concerns from the U.S. manufacturers about dumping of Chinese panels?
Well, so that is very interesting what you say, because you have the anti-dumping agreement in the WTO. So the anti-dumping agreement is a very interesting agreement because it basically, in pure economic sense, would be seen as anti-competitive, because that agreement gives you the possibility to impose duties, as you say, to protect from foreign imports of the same product. So what that agreement does is basically, if you are a US solar panel producer, you could institute duties against Chinese solar panels because you will claim that China is dumping those panels, meaning that they are selling those panels in the US at a much lower price than they are selling them in China. So you will have to prove that, and there's all kinds of calculations. So this is actually the protectionist mechanism. However, the problem is that, or it's not a problem, but countries that China can start then a dispute settlement proceeding and can basically say, well, you haven't calculated correctly and we are not dumping. So these duties, in fact, are protectionist in nature, but they were a compromise because indeed local industries wanted to have at least something that they could do to protect their national industries. But the question is, how long can you do that for? And in the end, if you look at the overall picture, it just means that you are subsidizing less efficient local producers of solar panels. I mean, there's so many sides to it, right? Because maybe you do want to have a strong national solar panel industry, but maybe you can also profit from cheap panels from abroad because that will make it cheaper for the actual producers of solar energy in the US. So it's it has many sides to it. But the anti-dumping agreement allows you to protect your national industries in this sense. The same was done with Germany. Actually, Germany had anti-dumping duties on solar panels, or the EU, but on behalf of Germany because, of course, the German industry was the biggest solar panel industry in Europe. Also, just so you know, I was talking about the WTO, and it's a state-to-state dispute settlement mechanism, but it will, of course, often be the lobbies of an industry that will try and convince the state to start a dispute settlement against another state because they are suffering from their industry activities over there. Any other questions?
I was curious about, you had mentioned that there are no exceptions for renewable energy incentives or subsidies, and I'm curious if that's an area of the case law you see developing as far as being able to fit them in with one of the Article 20 exceptions.
Yeah, I mean, so that one way would be to go to Article 20, but there is nothing in the GATT that says that it applies to the subsidies agreement. So that would be difficult, but that would be one potential way of going about it, and I hope it would go that way. That would be tested. It would be better to have a development of the subsidies disciplines to include some kind of policy rationales for subsidies that would be legitimized. But Article 20 exceptions could be tested, and then you have to maybe go into animal, plant life, or health, or exhaustible natural resources under Article 20 of the GATT. But I mean, it's interesting because the subsidies agreement didn't initially have some general exceptions in it. So that must have also been for a reason, because often subsidies can be protectionist in nature, and it's a very fine line. So yeah, welcome.
If there aren't other questions, I'll ask one.
Yes.
How do you understand the need for the WTO at this point vis-a-vis climate change? Is it an impediment to making progress? Is it necessary for addressing climate change? Just what's your thinking on the relationship between the organization and this massive global issue that we all confront?
Yeah, I think it should definitely be involved, and it should be coordinating more with, it already has some working relations with the UN, for instance, in certain areas, but I think the WTO should do more because, of course, the whole idea of international trade is to increase production, but with increase in production you will have automatically still in these times an increase also of pollution. So that just comes with it, right? So there is a Committee on Trade and Environment in the WTO, so they do deal with issues, but it's not huge efforts. So for instance, one initiative would be, which I hope will happen, to have, now you have a ministerial conference coming up. It would be great if you could, for instance, see some declarations on the elimination of fossil fuel subsidies. So as long as trade is directly linked to environment and adverse effects on the environment, the WTO is relevant for it. So I think it should take some proactive action. But I think the problem with the WTO is that very quickly people say, yes, but it's a member-driven organization. So we don't do anything what the members don't want. So in the end, it's up to the members. If they can come up with a declaration that they, for instance, want to phase out fossil fuel subsidies, as they actually did with agricultural subsidies recently in Nairobi, that would be a good way forward, slowly but surely. Yes?
I have one more question. You started out very nicely with the notion that the premise of this is comparative advantage. And yet, it seemed as you were presenting its history and the exceptions and so forth, that many of these exceptions were challenging the assumption of comparative advantage by introducing new values, et cetera. To what extent, by making adjustments in the system, at the same time that it's being challenged in terms of its fundamental principles, are you kind of like Ptolemy, that is, developing epicycles to try to adjust the system, rather than returning to its fundamental premises and asking, is this a sensible fundamental premise to have?
Yeah. I think we cannot do that anymore, especially in these times, what we see now. So, I mean, the economic theory behind it is, of course, nice, but reality is always different. We will see economic theories work nicely on paper, but work out different in reality. We see it now. So if it would go back to die-hard trade rules, no rules on environment or any other negative externalities, you will still end up with those negative externalities in reality. And so you will have to mitigate those somehow. So of course there's a limit. As I said, it's a fine line between venturing into all kinds of areas endlessly. So the WTO it's not the role of the WTO to necessarily protect wildlife directly. But as long as it pertains to trade, I think you should have corrective mechanisms. And so this is also a reason why these exceptions exist, because you do have to give states regulatory policy space. It's not all about trade. I mean, you could see if you only look at supply and demand, it doesn't take care of many other things in life. So it's a holistic picture, I think. Yeah. Yes?
You mentioned that a lot of energy-producing states are members of the WTO, but not the Energy Charter Treaty. Do you think that these energy-producing states see it in their best interest to keep the current subsidy structures in the WTO the way they are, that allow them to subsidize fossil fuel interests while banning renewable subsidies?
Yeah, I do think so. Yes, although, I mean, the Energy Charter Treaty is not better in that respect. It won't curb fossil fuel subsidies, for instance. It will have more detailed rules on trade in energy and investment in energy, but it won't curb fossil fuel subsidies. Yeah, but of course, countries are trying to be protectionist by nature. So if you have a strong fossil fuel production or exploration industry, you will try and protect that no matter what. But what you mentioned with the Energy Charter Treaty and the WTO is interesting, because the Energy Charter Treaty is the specialized trade and investment treaty for energy globally. And you see that the WTO is kind of taking over, because no disputes on energy trade are being litigated in the Energy Charter Treaty, but all these countries have joined the WTO in the meantime, and you see that they are being litigated there. So you kind of do see a shift in institutions and what is being litigated. But of course, that's the whole problem. It was the same with agricultural subsidies, right? Countries have a reason they institute them. It's often linked to employment. Fossil fuel subsidies are often linked to employment, industrial policy, etc. And it's very difficult to phase them out. Plus, most countries have them in place, and there is no clear monitoring mechanism on what fossil fuel subsidies look like, what forms they take, how many are there globally, you know? So you should maybe first have a monitoring mechanism. Actually, I think the IMF has published a big study on fossil fuel subsidies and the lack of any monitoring mechanism. Because you shouldn't only, you know, promote renewables, you should also tackle these kinds of subsidies.
Any final questions? Okay, with that, let's thank our speaker and make a break for it.